Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Intan Syafiqa binti Abdul Salam and my matric number is 1201584. So today I will give my opinion on the topic administration of Muamalat Islamic finance. Should a resolution of the Syariah Advisory Council bind in Islamic banking and finance dispute? First of all, we need to know that Malaysia adopts a dual banking system policy. Islamic banking operates in parallel with its conventional banking with similar financial infrastructure. Alright, back to the question that I have mentioned just now. In my opinion, the answer is yes. A resolution of the SAC should bind in Islamic banking and finance dispute. Central Bank Act of Malaysia 2009 also stated that the financial system in Malaysia shall consist of the conventional and the Islamic financial system. To make it clear, this Act has granted the authority to the CBA for the establishment of the SAC as the highest and sole authority to be referred by the civil courts in dealing with Islamic banking, takaful, and Islamic finance cases in Malaysia. So now let's move to the legislation that govern the Islamic banking, finance, takaful, and the securities. Under Section 56, this part stated that any proceeding relating to Islamic financial business or Sharia matter, the court or the arbitrator shall, number 1, to consider any published rulings of SSC, or number 2, refer to the SSC for its ruling. Then, any request of advice or a ruling of SSC shall be submitted to the Secretariat. However, in Section 58, where the ruling given by a Sharia body or committee constituted in Malaysia by an Islamic financial institution is different from the ruling given by the SAC, the ruling of the SAC shall prevail, meaning that if the ruling given by the Sharia committee is different from the SAC ruling, so the SAC ruling shall prevail as the sole authority ascertaining Sharia matters for Islamic finance in the judicial system. In the case of JRI Resources Sendian Berhad vs Kuwait Finance House Malaysia Berhad 2019, so what happened in this case? The respondent, KFH, had granted Islamic credit facilities to the appellant, which is JRI, in the purpose to finance the leasing of shipping vessels owned by the KFH. When JRI failed to pay the amounts due under facilities, the KFH sued JRI in the High Court for the amount owing. Then, in the Court of Appeal, JRI argued that it was unable to generate income from the lease of the vessels because KFH failed to carry out major maintenance works on the vessels. In Clause 2.8 in the Facilities Agreement, JRI is responsible to manage the cost of the maintenance of the vessels. But then, JRI argued that the clause contravened the principle of Sharia. The court sought opinion from the SAC ruling under Section 56 of CBMA. There are 2 points according to the SAC. Firstly, SAC said even though KFH should bear the maintenance cost of the vessels as their owner, it was permissible for the contracting parties to negotiate and agree as to who should bear the cost. Secondly, SAC ruled that Clause 2.8 was Sharia compliant. Therefore, JRI was obliged to bear the cost of the major maintenance works on the vessels as agreed between the parties. The issue arise here is whether Section 56 and 57 of CBMA was constitutional and has stripped the judicial power of the court under Article 121 of Federal Constitution. Next, the Federal Court held that Section 56 and 57 of the CBMA were constitutional and did not breach the Federal Constitution. The ruling of the SAC under Section 57 of the CBMA did not conclude or settle the dispute between the parties arising from the Islamic financing facility. This is because the SAC only ascertained the Islamic law for the purpose of the Islamic financial business. The determination of a borrower's liability under any banking facility was decided by the presiding judge and not the SAC. That's all from me. Thank you.